I said, the rules that they recently put into, or the changes or the clarifications are exactly that. There are no substantive changes to the rules that went into effect in 2009. But as you know, in 2009, they made some changes to RESPA to more timely and effective disclosures on the settlement costs, the standardized GFEs so that the borrowers could shop around a little bit easier, more accurate estimates, disclosure of yield spread premiums. Those all went in effect a couple of years ago. The clarification that was issued in July didn't have a period of time for comments because, again, they just felt they were clarifying what had already been stated. And these are some of the clarifications. Until the applicant receives a GFE, the lender can only charge for a credit report. They cannot charge anything up until that time. And the borrower must indicate an intention to proceed before the lender can charge any additional fees beyond the credit report. And, I felt that was clear, but again, they get a lot of questions about these things, and so they go back and try to reword some things to clarify the issues. In some sections, they would use the term new, and what they meant was revised, so they cleaned that up. The GFE expires 10 business days after GFE is provided, and that is for a new or a revised GFE, and they cleared that one up. When an interest rate is locked, you must provide the revised interest rate to the borrower. The revised interest rate dependent charges in terms within 3 days of when the interest rate is locked. And again, just more clarification. There's a section in RESPA dealing with, it was entitled New Home Purchases. And what it allowed a lender to do is to disclose to a potential buyer on new construction where the closing is going to be way out sometime in the future, that the lender had a right to issue a new GFE anytime within 60 days prior to the closing date. And that particular section was called New Home Purchases, and what they wanted to say was new construction home purchases. They didn't want to give people the impression that just because it was new, the home was new to the borrower, that particular provision applied to them. It was strictly provided for new construction home purposes. If a consumer doesn't ultimately purchase a service on the GFE, then such a charge should not appear on page 2 of the HUD-1. So, you try to match up the GFEs, trying to look more like the HUD-1 so they can compare those costs. But in the event you have an estimate on the GFE that they actually don't incur that cost at closing, then you're not going to find that number on the HUD-1.
Does that include things that they have to put on there and remove?
Yes. Yeah,
They're still doing it though.
Yeah.
Okay.
I think that's the point of the clarification, because that for some reason it was showing up things that were on the GFE that they ultimately didn't purchase were showing up on the HUD-1, and then their adjustments were being made. So they tried to clarify that it shouldn't even be on the HUD-1 in the event that the service is not used, not charged. How many of you, I don't know how many of you might be doing Fannie Mae listings? Anybody? One person. I'm just talking to a couple people. Okay, well, Fannie Mae has a new policy now, and they did say, and you saw this in your listing agreements, that a listing broker should not represent both the seller and the buyer in the same transaction. That was in Fannie Mae's listing agreement. They decided they're not going to enforce that term, and they're going to stop incorporating it into their listing agreement. So if you do any Fannie Mae work, you can represent the seller and the buyer in the transaction. So that's good news. The qualified residential mortgage. You guys heard all about this? Everybody knows the QRM? Yeah. Okay, so we're watching this very, very carefully. Under the Dodd-Frank Act, one of the things that the Dodd-Frank Act does, of course, is to try to make lenders more responsible in making loans. And one way that they've come up with to do that is to require lenders to retain a certain amount of the loan on their books when they sell to the secondary market, if the loan is not what they call a QRM, okay? So, and how they define a QRM right at this point is problematic, and the main thing that's problematic is the 20% down. So, for example, if a lender makes a loan that is not a QRM, when they sell, they have to retain 5% of that debt on their own books. So, of course, they're encouraged to make these QRMs, but one of the requirements for a QRM right now is 20% down. Another point is limits mortgage payments to 28% of the gross income. Borrower can't be more than 30 days or more past due on the debt. Can't be more than 60 days past due in the last 24 months. Can't have bankruptcies, foreclosures, short sales, these kind of things within the last 36 months. This is the definition of QRM. consumer groups and NAR, of course, have criticized this 20% because only 39% of the mortgage made in 2010 had a 20% down payment. So we are eliminating a whole lot of people from the QRM by requiring them to put 20% down. It takes the average family almost 9 years to save for a 10% down payment. That's what the statistics are showing. And of course, if they can't get a QRM, so that the lender can't sell the entire loan to the secondary market, and the lender has to retain some of it, then they're going to want more money for that loan because they're going to have to retain some of that risk. So they're going to charge higher interest rates, they're going to charge higher points, more upfront fees. All of these things are going to be associated with non-QRM loans. So obviously right now, everybody's had a real problem with that. They did have a comment period. They extended that comment period to August 1st, so that just ended. Even the drafters of the rule, the ones that of the Frank Dodd Act who created these provisions, actually sent letters to the regulators who were drafting the regulations to accompany the law that said this is not what we had in mind. And they're not trying to stifle home ownership and the ability of people to get loans in this market. So you guys need to really take a look at this again. So I don't anticipate that this is going to stick just because they've gotten so much pushback, but we're keeping an eye on it, and NAR is being very, very vocal and trying to deal with this issue. Okay? Yes?
Just a point on that. I'm with New Mexico Bank and Trust. We're direct lenders to Fannie Mae. That does not apply to Fannie Mae or Freddie Mac or FHA or
Yes,
VA.
or VA, right, exactly.
13% of the private labor lenders.
Right, right, exactly. And who knows how that's going to shake up with Fannie and Freddie down the line after they get out of receivership. I mean, all that sorts itself out. So we kind of want to look down the line in creating this law because it might eventually affect them. So yes, but thank you, good point.
And who does it apply to if it's not Fannie Mae, Freddie Mac, or FHA? Or
Yeah, straight
Or
conventional.
VA.
That's right.
So it's straight conventional.
But like I said, that's only for now. I mean, this law will be in, or these regs will be in effect down the line, and I think eventually, I don't anticipate it'll ever apply to FHA or VA, but it might apply to Fannie and Freddie down the line. So we kind of have to look in that direction and deal with it now.